Hello, this is Ricardo and welcome to CleanTech and WFF's Respect in the Workplace training session. This training is required for all leadership staff because quite frankly the topic has a high potential of risk for both the individuals and the company. However, we don't want you to think about this training merely in terms of legal risk, rather as an extension of how we as leaders should role model and be vigilant about respectful behavior between one another. Personal accountability, respect, and integrity are interwoven into this training for any behaviors which cross lines with regard to our associates' ethnicity, gender, national origin, color, or religion, infringe on our firmly held company values and our associates' dignity. As you may know, I often take practical examples to things, and when it comes to judging what behaviors may cross the line and cause you to take pause or action, think of these in terms of behaviors you would not wish directed towards a customer or a student. But if you really want to keep it real, I once asked the manager, how would you feel as a father if your daughter came home one day and repeated to you what this supervisor said to her? I can tell you from personal experience how I felt when my 72-year-old father told me about how an associate at Lowe's mocked him for asking for help at their kiosk when trying to fill out a job application. Sometimes it needs to get personal for us to be sensitive on how words make people feel. Just as important as the actions you take with these matters are those that you choose to ignore. When someone tells a joke about a person with a disability or with a racial slant, you laugh alongside the rest, your tacit approval or lack of visible action signals to others that you're tolerant of disrespectful commentary. Rest assured, employees will take note of your lack of action and include it to support a claim. Our intent here is not to make you a legal expert on the matter. However, covering regulations provides you with basic to intermediate level of knowledge. The most important takeaway for you today is to first recognize and immediately address issues which may have the potential of escalating if ignored. Finally, while we do not want to minimize anyone's complaint or feeling of harassment, not all obnoxious or rude behaviors rise to the level of illegal harassment. Some are simply the feeling of being singled out, being picked on, or simply disrespectful exchanges between frontline supervisors or coworkers. Regardless, they still need to be dealt with. So now let me turn it over to Melinda so she can provide you with the more formal or legal concepts for you to be mindful of. Melinda?
Thanks, Ricardo. During this course, you will learn about a couple of key items that you need to know in order to create a safe environment for you and your employees. We will define what unlawful harassment is, what characteristics define a protected class, what is considered a hostile work environment, find out what your responsibilities are as a supervisor and manager, and gain knowledge about the complaint and EEOC process. In today's workplace, nearly everyone understands that harassment is a serious issue. Check any employer's policy and you'll find a list of behaviors that are not appropriate at work, and in some cases, illegal. Yet even when the attention the issue gets, it's not always easy for employees to recognize it or to know what to do if they see it happen. As a manager, you have the responsibility to understand what harassment is and what role you play in responding to it if it should occur. In this course, the term unlawful harassment refers to any unwelcome conduct directed at an individual who is a member of a class that is protected by anti-discrimination law. To meet the definition of unlawful, the behavior must negatively affect the victim's working conditions or terms of employment. Let's now take a look at what characteristics define a protected class. The U.S. Equal Employment Opportunity Commission, known as the EEOC, enforces federal laws that prohibit discriminatory practices based on certain protected characteristics or classes. These laws include Title VII of the Civil Rights Act of 1964, the American with Disabilities Act, which has been amended and is now referred to as the ADAAA, the Age Discrimination in Employment Act, or the ADEA, the Pregnancy Discrimination Act, also known as the PDA, and the Genetic Information Non-Discrimination Act, or GINA. Title VII of the Civil Rights Act of 1964 protects employees from discrimination in the workplace that is based on any of these classes or personal characteristics. Race, a person's ancestry or physical or cultural differences. Color, a person's pigmentation, complexion, shade, or tone of a person's skin. National origin, a person's birthplace, ancestry, culture, or linguistic characteristics. Religion, religious beliefs or non-beliefs. And sex, a person's gender, whether they're male or female, and their sexual orientation. In addition to the classes protected under Title VII, there are 4 other federally protected characteristics. Disability, which is covered by the ADAAA, includes any physical or mental condition that limits a major life activity, such as walking, talking, hearing, or learning. Age, which is covered by the ADEA. Employees who are over 40 are protected from discrimination and harassment. Pregnancy, which is covered by the PDA. The state of being pregnant as well as childbirth. This includes any medical condition related to the pregnancy or the childbirth. And genetic information, which is covered by GINA. Any family medical history used to determine if someone has an increased risk for getting a disease, disorder, or condition in the future. In addition to the protections under federal law, some state and local laws also protect an employee's marital status, political affiliation, or status as a parent. Sex is not the only characteristic that can be a target for unlawful harassment. Remember, there are several other federally protected classes that may be the basis of harassment. Some states' laws include more categories. For example, race or color, ancestry or national origin, religion or creed, age over 40, disability, both mental and physical, sex or gender, which includes pregnancy, childbirth, breastfeeding, or any other related conditions, sexual orientation, gender identity and expression, medical conditions, genetic information, marital status, and military or veteran status. Under federal and state anti-discrimination laws like Title VII, hostile environment harassment is defined as conduct which is based on a protected category, such as an employee's race, color, religion, sex, which includes pregnancy, national origin, age, 40 or older, disability, or genetic information, that is either severe or pervasive enough to create a work environment that a reasonable person would consider intimidating, hostile, or abusive. So far, you've learned how harassment can be unlawful if it's based on a protected class. But you may also be wondering, is any thoughtless comment to an employee about a protected characteristic unlawful harassment? Maybe not. For the conduct to be considered unlawful harassment, it must create a situation that unreasonably interferes with the victim's working conditions or terms of employment. This behavior must be unwelcome and of a kind that a reasonable person would find either severe or pervasive. If these characteristics exist, the result is hostile environment harassment. These include any unwanted touching, threats, violence, or any situation that causes an employee to feel unsafe. You may have noted the term reasonable person. Because people bring different experiences and viewpoints to the workplace, the law evaluates a harasser's conduct against the reasonable person standard. The idea is to put aside any personal sensitivities of the victim and consider the situation as objectively as possible. Rude or obnoxious colleagues can make anyone unhappy. Their behavior is never welcome. But unless it's aimed at an individual of a protected class and is severe or pervasive, it is not against the law. So far, you've learned the definition of hostile work environment harassment, but it's not the only type. Another form of sexual harassment is known as quid pro quo. The Latin term for quid pro quo means this for that. In the context of harassment, it refers to situations where a manager or supervisor demands that an employee submit to sexual advances or perform sexual favors as a condition of the employee's job. Quid pro quo harassment only arises in cases where supervisors abuse their position of authority and coerce employees into engaging in sexual activity. A critical aspect of quid pro quo harassment is that the supervisor or manager promises some type of employment benefit if his or her advances are accepted, or a negative consequence if they are rejected. This is called conditions of the employee's job. Even if the sexual favors are granted and the employee receives the promised employment benefit, quid pro quo harassment has still occurred if the employee felt he or she had no choice but to submit to the manager's demands. For example, Jackie's boss tells her he can make her job a little bit easier if she just agrees to sleep with him. Negative consequences for the victim are known as tangible job detriment. Tangible job detriment might take the form of either being involuntarily reassigned, getting passed over for a promotion, receiving a reduction in benefits, being demoted, or even being terminated. For example, Thomas resisted his boss's sexual advances, and he was passed over for a promotion as a result. As a manager, you have the important responsibility when it comes to keeping your workplace harassment-free. For instance, it is important to remain observant of the employee's behaviors and recognize the conduct that would be considered harassment or could potentially lead to harassment. And you should proactively address inappropriate conduct even if it's relatively minor, before it escalates into something more serious. So far, we have defined unlawful harassment, learned what is considered a protected class. So now let's take a look at what sexual harassment and hostile environments are and what you as a supervisor or manager can do to prevent it. The EEOC provides a definition of sexual harassment as Any unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature constitutes sexual harassment when submission to or rejection of this conduct explicitly or implicitly affects an individual's employment, unreasonably interferes with an individual's work performance, or creates an intimidating, hostile, or offensive work environment. When the EEOC refers to verbal or physical conduct of a sexual nature, it's talking about behaviors that, due to the focus on sexual conduct, are not acceptable in the work environment. As a supervisor or manager, you are responsible for recognizing and addressing these types of behaviors if they should occur. Consider some examples of prohibited behavior. Sending dirty jokes and sexually explicit images over email or through social media sites to another employee. Sending unwelcome and sexually explicit text messages to a colleague. Repeatedly pestering a coworker for a date. Groping, leaning over, cornering, pinching, or in any other way inappropriately touching another colleague or employee. And making sexually suggestive gestures or signals. It's important to note that conduct that can create hostile environment sexual harassment does not necessarily have to be overtly sexual in nature. Any unwelcoming harassed behavior that is directed at individuals based on their gender can be considered sexual harassment, even if no sexual advances are involved. For instance, an individual could be subject to taunts, jokes, or other verbal abuse for having undergone a gender reassignment. It is also important to understand that sexual harassment can be indirect, affecting a witness or onlooker who is not the direct target of the behavior. As you've learned, quid pro quo harassment refers to situations where a supervisor demands sexual favors in return for work benefits. The EEOC's definition covers this type of harassment when it states that unwelcome sexual requests or favors are requested and affects the individual's employment. When we talk about hostile environments or sexual harassment, this can make employees feel a certain way. We call this abusive conduct. Abusive conduct, if allowed to occur in the workplace, can result in extremely harmful effects for other employees or victims. Some of these effects include increased stress, depression and anxiety, eating disorders, sleep disorders, physical ailments, and other negative impacts to the mental and physical health. Abusive conduct is also harmful to the organization as well because it personally affects can lead to decreased morale, lower productivity, disengagement by employees, and high turnover. Therefore, as a manager, it's crucial to ensure your interactions with others are at all times civil, respectful, and professional. Also, if you should witness any conduct that you think is abusive, intervene and alert HR. Failure to recognize harassment when it occurs or failing to act as you should when you see it can expose your company to substantial legal liability and many other negative consequences. Harassment can always have a negative emotional impact. Victims of harassment are likely to experience symptoms of fear, anxiety, stress, and depression. Clearly, it's wrong for employees to be made to feel that way at work, and it's not in the company's best interest to allow this to happen. For one thing, emotional distress can lead to absenteeism, which may end up costing the company a great deal in lost productivity. Workplace harassment also affects employee morale. It's hard for an employee to stay enthusiastic and focused on the job when the workplace has become hostile and threatening. And when other employees see that it's going on, they may begin to feel uncomfortable and anxious too. As harassment damages workplace relations, it disrupts teamwork and cooperation among employees. This can have a domino effect on your company's performance. In addition to causing damage to workplace performance, harassment can have serious legal and financial consequences for companies who may be held liable for employees' misconduct. Companies that do not take the steps to prevent and address harassment may face certain legal sanctions or penalties for violating the law. Some of these include: the victims may be awarded back pay for the time they are not at work due to the harassment. Employers may be required to pay compensatory damages to the victim for the emotional distress caused by the harassment. The court may order that a victim be reinstated, promoted to a former position, or promoted to a new position if he or she was fired or demoted after refusing to submit to harassment. This is known as equitable relief. Employers may also be ordered to pay attorney's fees to victims, and in some situations, a court may issue an injunction that requires the employer to put a stop to the harassing behavior. Apart from sanctions that employers may face, in some states, managers can also face individual liability with civil and criminal penalties for harassment that they commit. Where an employer's conduct is found to be intentional, willful, or malicious, the courts may also permit an award of punitive damages. Punitive damages are intended to punish the employer and to discourage further unlawful conduct. For these reasons, punitive damage awards are usually quite large. In 2014, the EEOC received nearly 27,000 harassment complaints and recovered almost $94 million in monetary benefits for harassment victims. This figure does not include the awards obtained by victims through litigation, which typically run into the hundreds of millions of dollars annually. The high incidence of harassment claims and the monetary penalties they present clearly indicate that harassment is not an issue any organization can afford to ignore. In addition to the sanctions we already discussed, dealing with harassment investigations and lawsuits can be time-consuming, stressful, and expensive. For all of these reasons, it's important that as a manager, you remember your role in preventing harassment. Under federal law, employers can reduce their liability for their manager's wrongdoings by establishing an affirmative defense. There are two elements to this defense. First, the employer must show it took reasonable steps to prevent harassment from occurring. This means establishing an anti-harassment policy, and that the managers and HR personnel respond quickly to all harassment complaints. Lastly, it protects complainants from retaliation. Secondly, the employer must show the complainant did not take advantage of opportunities provided by the employer to correct their harassing behavior. This often happens when the victim fails to report their harassment, even though the employer established a process for doing so. The affirmative defense is not available under some state laws. However, California, Michigan, Missouri, Massachusetts, and Illinois, for example, hold employers strictly liable for harassment. Nevertheless, examining the elements of the federal affirmative defense can help show how companies and their managers can reduce the likelihood that harassment complaints will occur in the first place. As discussed, a company can help prevent harassment by implementing a policy that makes it clear its behavior's expectation in the workplace. The EEOC recommends that employers cover the following 4 areas in their policies. An anti-harassment policy should address the employer's commitments to its employees in several ways. First, by declaring a zero tolerance for harassment. The policy should state the company's position on discrimination and harassment, making it clear that such conduct is not acceptable. Secondly, by committing to a no retaliation policy. A no retaliation policy states that making harassment complaints in good faith will not result in any negative consequence to the employee. This protection from retaliation also extends to any employees who assist a harassment victim in filing a complaint or who participate in a harassment investigation. And thirdly, assuring confidentiality to the extent possible. The commitment to confidentiality assures employees that all reasonable efforts will be made to maintain their privacy following a harassment complaint. To ensure employees have a clear understanding of prohibited behavior, there are 2 other items the policy should include. First, the definition of different forms of harassment and examples of prohibited conduct. The harassment policy should also provide information about the procedure for making and resolving complaints. The complaint procedure, which should include multiple points of entry for employees who wish to make a complaint. And lastly, an employee training requirement. By now, you know that as a manager or supervisor, you have the responsibility to ensure your employees can do their jobs in an environment free of harassment. But more than that, you have the opportunity to set the tone in your workplace. Your actions and attitudes filter down to those that you manage. You're in a position to model the respectful types of behavior your company expects, and by doing this, you encourage your employees to do the same. Do not wait for a complaint to be made before dealing with a possible harassment issue. Be proactive in responding to any conduct you think might lead to harassment. A few well-chosen words may be enough to head off a complaint, and by taking preemptive action, you're showing that you're serious about harassment, which will deter offenders and encourage victims or witnesses to report any harassment that does occur. Follow the following steps to proactively intervene. First, deal with the incident quickly and as soon as possible after the occurrence. Speak to the employee who's responsible for the problem in private. Specify the problem behavior and explain why it could be considered harassment. Gain the employee's commitment that it won't happen again and document what happened. Making a correct decision to intervene is one thing. Knowing how to intervene the right way is another. Consider the following example and think about how the manager handles the situation. Maria is managing a team of call center workers. One day, she noticed that James, a recently hired member of the team, has put up a poster of a barely clothed pop star at his desk. Maria has a short temper and hasn't been impressed by James's sales performance so far. She loudly tells James to grow up and get that smut off your desk. Before ripping up the poster off the wall, she warns James, if you ever pull a stunt like that again, you'll be fired on the spot. You'll probably agree that Maria did not handle the situation in the best way. Some intervention was called for, but Maria could have been far more effective. Maria was right to intervene quickly, as a poster like this could certainly cause offense to some of James's co-workers. But she failed to model respect by staying calm and speaking in a way that wasn't demeaning to James. Instead, she resorted to aggressive and violent behavior. Another problem with Maria's response to the situation was that she should have been specific with James about why his conduct is wrong. This would have been best accomplished in private and a non-combative conversation. Instead, Maria seemed to be venting her general frustration with James's performance, which was a completely irrelevant issue, in a public way. After explaining to James what's wrong with displaying the poster in the workplace, she should have gotten a commitment from him to be more considerate in the future and not hang any posters that his co-workers would find objectionable. And finally, Maria should have documented the situation for future reference if necessary. If Maria had any doubts about the best course of action, she should have contacted HR. If an employee comes to you with a complaint, keep in mind the following when handling the situation. Listen to the complaint with an open mind. Be sympathetic and avoid expressing any doubt. Be respectful to the complainant. You should be consistently respectful in all of your interactions with your employees, especially when they come to you to report a harassment situation. Avoid saying things that might insinuate that you're too sensitive or that the alleged harassment didn't occur, which would be trivializing to the complainant. Even if the incident seems unimportant to you, it's clearly not unimportant to the person making the complaint. Reassure the person that the company takes such issues very seriously. Explain the limited confidentiality of the investigation process. It's quite likely that the complainant will be worried that what they're reporting will be publicized. You can assure the complainant that you will keep things confidential to the extent possible, but that you will share your report with HR. Lastly, follow the company's policy. When it comes to handling a complaint, it's important to follow the procedures outlined in your company's policy. Following a harassment complaint, conducting the investigation is HR's responsibility, not the manager's. But it's important that you know something about how the investigation process works, as you may be asked to assist with some or all aspects of the investigation. There are 3 steps in the process. First, interviewing. In order to gain the facts, the investigator will interview the individuals involved and other employees who may have witnessed the incident or behavior. The complainant will be asked about when, where, and how often the alleged harassment took place. The accused will be informed about the allegations and allowed to respond. Witnesses may also be asked what they know about the alleged incident or behavior, and what their relationship is to the complainant and the accused. Secondly, drawing conclusions. Once the information is gathered from the interviews, the investigators will review the evidence to determine what occurred. And lastly, communicating the decision. Once a decision is reached, the investigator should meet individually with the complainant and the accused. If it is determined that harassment did occur, the harasser should be informed of any disciplinary action that will be taken. If an employee approaches you with a complaint, you should listen respectfully, document the conversation, and communicate the complaint to HR according to your company's policy. Remember, always avoid any form of retaliation. When an employee comes forward with a complaint, they do so generally about how matters will be handled, but most importantly, if anything will be done about it. The closeout letter is a document which is drafted by HR, which is used to show you the following. We will address any actions that the company took. It helps inform the complainant of the findings and the actions taken to prevent it from occurring again. It helps bring closure and reaffirms that we have a non-retaliation policy and that we take these matters seriously. And it also provides documentation. This document also informs the complainant in no specific terms that the company took action on the matter with the alleged harasser. There have been instances where we have informed the complainant that we could not corroborate the policy violations that occurred, but it's still important to demonstrate that we looked into the matter. Finally, to ease concerns, the closeout letter reaffirms our non-retaliation policy. Let's take a look at an example. As you can see, the letter shows exactly what is summarized to the complainant and or the alleged harasser. First, we identified what inappropriate conduct took place. We then reconfirm that we do not tolerate this type of behavior and that we want an environment free from anything occurring like this again. Thirdly, we acknowledge that HR has completed an investigation with both parties and has taken action. Lastly, it summarizes that we took all appropriate steps necessary to conduct a thorough investigation. The stakes really get high for a company when a supervisor is the harasser. Let's cover who is considered a supervisor. A supervisor has the power to affect the duties or employment status of their employees. The supervisor also has the power to affect the daily work and activities. When it is determined that a supervisor, as defined by law, has engaged in appropriate behavior and furthermore has proceeded with a tangible employment action such as a raise, transfer, demotion, promotion, or actions which can be positive or negative, the company may be held liable for the actions of that supervisor. Let me give you an example. Frank is a supervisor who's responsible for Jane, a new employee. Frank provides his boss, Sam, with feedback about Jane's progress during her probationary period. Sam concludes she's not a good fit and directs Frank to dismiss her. During the meeting to inform her of the dismissal, Frank makes a sexual overture which Jane finds offensive. Jane files a charge. Is the company liable for Frank's actions? Technically speaking, the company may not be responsible because the tangible employment action was not made by Frank. He merely followed Sam's direction. The company discharges Frank as the remedial action on their part to resolve the issue and limit further exposure. Now let's suppose Frank not only provides performance feedback, but also is the one making the decision to pass or fail the probation. In this case, Frank, as supervisor and the harasser, also takes the tangible employment action. The company discharges Frank for his actions as the remedial action. However, in the eyes of the law, that may not be sufficient, and now the company, in addition to Frank, will be held responsible. It is possible that a complainant could confront you directly, or you may hear about a complaint from another manager or from HR. The first thing you should do is take that complaint seriously. If HR is not yet involved, notify them immediately. If HR is already involved, you must keep them informed of anything related to the complaint that develops. Also, avoid repeating the behavior that caused the complaint, and it's extremely important that you avoid taking any retaliation against the complainant. Instead, respect the complainant and maintain confidentiality between you, the complainant, and HR. Under the law, retaliation for harassment complaints is considered a type of harassment in and of itself. In fact, retaliation claims are the fastest growing category complaints that the EEOC receives. One important aspect of the company's effort to reduce harassment is its openness to receiving all complaints about harassing behaviors. Employees must feel comfortable making use of the complaint procedures available to them if they should ever feel that they're being harassed. This allows the company to receive complaints and act on them before the problem escalates further. According to the EEOC, retaliation occurs when an employee takes an adverse action against a covered individual because that individual is engaged in protected activity. Let's consider the following 3 key points. First, there are 3 protected activities. First, opposing discrimination and harassment. This includes making a harassment complaint. It also covers refusing to obey an order that reasonably believed to require the employee to engage in harassment. Secondly, participating in a discrimination or harassment investigation. This includes serving as a witness in an investigation or court proceeding. And thirdly, requesting a reasonable accommodation. Requesting a reasonable accommodation based on a protected class, such as the religion or disability, is a protected activity. Retaliation in response to any of these 3 kinds is against the law. The next key term in the EEOC's definition is covered individuals. These are people who have engaged in a protective activity, just like we mentioned. People who are closely associated with covered individuals are also considered a covered individual. For example, it is illegal to terminate an employee because his spouse served as a witness in a harassment investigation, or to demote an employee who helped her friend come forward with a sexual harassment complaint. The final key term in the EEOC's definition is adverse action, which is a negative employment action that would be likely to deter someone from taking part in a protected activity. Adverse actions include an involuntary transfer, demotion, or termination on the pretext of poor performance and unjustified negative evaluations or reference. Actions that are not covered as adverse actions include stray negative comments in an otherwise positive or neutral evaluation, or negative comments that are justified by an employee's poor job performance. Also, employees that are not excused from continuing to perform their jobs or following company rules simply because they've made a harassment complaint. An employee who feels he or she is the victim of discrimination can file a complaint with an external agency, such as the EEOC. State agencies may also accept and process harassment complaints. In many cases, an employee will file a complaint with an external agency because he or she cannot find a resolution with the company. However, it is possible that an employee will file a complaint with an external agency before attempting to find an internal resolution. As a manager, the most important thing to remember is that you should report external complaints that you become aware of to HR immediately. Although you will not have the leading role in dealing with an external complaint, the following information is intended to help inform you about how the agency's complaint resolution process typically goes. The process for filing a complaint with the EEOC. First, the agency will open an investigation of the charge. The first step usually involves inviting the employee complainant and sometimes the company to sit down together with an EEOC mediator to attempt to resolve the issue. If that mediation is unsuccessful, the EEOC will continue its investigation. The next stage typically involves the EEOC requesting further information from the complainant and the employer. They do this by interviewing people with knowledge of the situation and reviewing any relevant documents. The EEOC's goal at this point is to determine whether it believes harassment has occurred. Once the EEOC completes its investigation, there are two outcomes. First, it decides not to pursue the matter further, or secondly, it does conclude that harassment has occurred. The EEOC's decision not to pursue the matter on behalf of the complainant does not mean that the EEOC has determined that discrimination or harassment has not occurred. Instead, the EEOC will issue a right to sue letter, which will file the complainant as an independent lawsuit if he or she so chooses. A complainant cannot file that independent lawsuit based on a federal discrimination law without first obtaining the right to sue letter from the EEOC. If, on the other hand, the EEOC concludes that discrimination or harassment did occur, it will issue a letter of determination and begin the process of conciliation. During conciliation, the EEOC will work with the complainant and the employer to negotiate a remedy for the discrimination of harassment. If conciliation is not successful, the EEOC may file a lawsuit on behalf of the complainant, or it may issue a right to sue letter so that the complainant can pursue an independent lawsuit. During an EEOC investigation, HR may request that you respond to questions, participate in interviews, and produce any documents you may have relevant to the complainant. This is another reason that documenting your conversations with harassment complaints is so crucial. You may also be asked to participate in the mediation discussions. Often, the company's legal counsel will be involved in preparing the company's response. At any time during the EEOC's investigation process, the complainant and employer may agree on a settlement to resolve the matter, which would then close the case. Remember that as an employee's protection against retaliation, it extends to the external complaint process, even if the matter is ultimately resolved in the company's favor. As a manager, you must be sure not to engage in retaliation either during or after the agency's resolution process. And be sure to report any retaliations you may observe to HR immediately. To review, workplace harassment has many negative effects, including reduced morale and productivity, and a range of legal sanctions that may be imposed on your company. Companies can sometimes use the affirmative defense to limit that liability if they can show that they've taken reasonable steps to prevent harassment. However, under the concept of vicarious liability, the affirmative defense is not available to limit the company's exposure in the case of the manager's unlawful harassment if the victim suffers a negative tangible employment action. As a manager or supervisor, keep the following bullets in mind when you're speaking with your employees. Recognize the various forms of sexual harassment that can take place and be able to intervene when you witness inappropriate behavior. Become informed with the company's policy and processes when handling complaints. Model, respect, and promote a harassment-free workplace. Avoid any form of retaliation against an individual for making a complaint. And report any complaints to HR immediately. Thank you for participating in Clean Tech Company and WFF Facility Services Respect in the Workplace training.